Hello, this is Matt on the Moon Lambo channel. Got two topics on the legal front to share with you in this very latest Moon Lambo hot jam. And the first one is that attorney John Deaton has now stated that it looks like he's going to be dropping yet another lawsuit on the SEC, and I will be explaining why. Tiny spoiler here. I guess that won't be too much of a surprise, but it's going to happen because the SEC appears to be intentionally hiding information, and they are not allowed to do that. That is not legal. Then I also have some perspective from attorney Bill Morgan, member of the XRP community. His thoughts on the ruling just the other day in the SEC v. Library case, which was, as most of you are aware at this point, a crushing defeat for Library, which is very regrettable. It was a very poor ruling. Just on the, if you look at just the facts, the logic, or lack thereof applied by the judge is not good. And I did a pretty full breakdown yesterday, but I want to share with you perspective from attorney Bill Morgan in this latest Moon Lambo hot jam. But before going further, I would like to be clear, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Damn it! If you don't like it, you can just get out. So let's jump on in. Here's what attorney John Deaton has to say. When Judge Deaton stated that the SEC, quote, lacks a faithful allegiance to the law, end quote, she couldn't have been more accurate. I was about to file a formal FOIA lawsuit in federal court because the SEC refuses to comply and provide Hinman's calendar. They called my office yesterday and said, we will be providing it today. But they gave me the same alleged calendar entries they provided to others. This is allegedly Hinman's calendar for June 14th, 2018. And here's a screen grab that attorney Deaton shared. Now, I'm not going to read this, but I am putting it up here if you want to pause it and read it yourself. Go right on ahead. But attorney Deaton ends up making the point as far as why he shared this in the first place. And here's why. He wrote, do you notice anything significantly missing from June 14th, 2018? Only the most litigated speech in SEC history is missing. This is not Hinman's calendar. It may be a calendar entries for the Division of Corporation Finance. And I was positive, of course, that was Bill Hinman's division within the SEC, Division of Corporation Finance. And then attorney Deaton says, but Hinman's calendar would include flight to San Francisco. It would include speaking at the Yahoo conference where he gave his infamous speech. And so the SEC denied my FOIA request. That's Freedom of Information Act request, of course, at first, because they said his calendar was personal and was not used for agency business. So pause to think about this. They said that it's personal and not for agency business, the calendar. So they refused initially to hand it over, and then they're like, okay, we're going to hand it over, and then they just handed over something else that they're saying is Bill Hinman's calendar, but clearly is not. What in the ever-loving hell? These people, they have no shame. They have absolutely no shame. This is awful. And so then attorney Deaton says, I laughed and then appealed, and the Office of GC agreed with me that a federal judge would laugh at them. Plus, the emails that Empower Oversight got via FOIA litigation prove that Hinman referred the ethics office to his calendar when he asked them to speak live about it and not email. And so here's how it wraps up, because there's going to be another lawsuit, looks like. Attorney Deaton says, looks like I will drop another FOIA lawsuit on the SEC. It really shouldn't be this difficult to get the calendar of a high-ranking government official. They can redact all the personal information they need to. They are hiding S-word. Plain and simple. My gosh. The SEC might be the worst government agency in the United States. I mean, if there's a worse one, you just tell me what, because I'm seeing real harm to real people as a result of all the stuff that they're doing here with minimal protection. I mean, fine, I like it when they go after the outright actual scams and all the rug pulls and that crap. But look at what they're actually doing. Look at what they're actually, who are they really targeting? Going after a library? My gosh, think about library. They raised what, like a couple $100,000 or something like that when they sold the tokens. And then you think about all of the genuine outright scams that the SEC could be focusing on, but is not. They just, I mean, fine, they do pick up some, but my gosh, it's completely absurd. And so speaking of the library case, now let's get into what attorney Bill Morgan has to say, now that he's had a little bit of time to digest this. He shared this information just an hour or so ago. And he did end up tagging me in this at the end. And so if you're listening, Bill, thank you very much for tagging me. I always find your insight very useful. You kind of break down what is sometimes difficult to understand stuff for lay people like myself, because I don't have a legal background, and most people listening don't have a legal background. It can be, the legal happenings, let's say, can be very complex. So I appreciate that you and others in the XRP community take the time to, make the very complex, something that can be actually comprehended by the typical people out there like myself. Anyway, here's what attorney Morgan had to say. I have read the library judgment now a few times, and it strikes me how narrowly focused was the main issue and how narrowly confined was library's defense on the Howey issue. The main issue is identified by the judge on page 8. The issue, whether the economic realities surrounding libraries' offerings of LBC, identified on pages 4 and 5, led investors to have a reasonable expectation of profits to be derived from the entrepreneurial or managerial efforts of library. The judge only considered evidence that concerned that issue and looked at only 2 categories of evidence: library representations and its business model, and then considered library's consumptive use argument. What follows is not a classic legal or logical reasoning. The evidence of library's representations is not overwhelming, and not just because there is virtually no evidence any LBC buyer was actually aware of or influenced by the representations. The judge on page 9 refers to multiple library statements the SEC allegedly identified, but only refers to a blog post, an email to one potential investor in 2016, another blog post in 2016, a Reddit thread, an interview, a 2018 article, and a post in October of 2020. The judge states on page 14 that these 7 pieces of evidence are representative of library's overall messaging about the growth potential of LBC, although the evidence is as much about growth and demand for LBC or in use of the blockchain as about growth in price or financial value. The judge, in my view, mischaracterizes part of the scant evidence he refers to, and then makes a leap from the evidence to a conclusion on page 14. Quote, and thus, the SEC is correct that potential investors would understand that library was pitching a speculative value proposition for its digital token, a form of inducement. There was no evidence cited of actual inducement, that any investor was in fact induced by these specific representations. The conclusion doesn't necessarily follow from the evidence and shows an error in inductive reasoning. For example, insufficient sample size, and the evidence is really quite ambiguous as to what was being represented. Disclaimers by library that, by their nature, are unmistakable in their intent were discounted by the judge. Just pause to think about this. The judge is making an assertion, and it's part of the reason he came to the conclusion that he did, which is that the SEC is right, and it is illogical. The logic doesn't follow, as cited here by attorney Morgan. The specific instances, my gosh, you're like, think about this. He's making a claim as to why people got into LBC in the first place, purchased LBC. And then just concluding that, of course, they would do it for, with the expectation that library would be making it worth more in the future. There isn't even sufficient evidence for that. Do you see what attorney Morgan's pointing out here? One of the things he's pointing out here anyway. That's why I like this ruling, and I covered it in great detail yesterday. It's an actual bad ruling. It really is. This judge not applying logic. That's my opinion. Anyway, attorney Bill continues. The judge also considered evidence, also scant, about library's business model, which was to keep a large quantity of LBC, which would increase in value as the library network was developed. This apparently, for the judge, signaled to investors that Library was motivated to work tirelessly to improve the value of the blockchain for itself and LBC buyers who would understand and expect they would profit from their LBC holdings. There is no evidence cited of an actual investor having this understanding or even knowledge of Library's business model. So pause to think about this. There's no evidence that what the judge is saying actually happened, but the judge makes the claim. This is a very bad rule. This is not how law should work. It really is not. And then Attorney Morgan says, these are serious adverse findings against Library from scant and not entirely unambiguous evidence. The judge tends to leap to these conclusions from a small sample size. Ironically, on page 17, he criticizes Library for leaping from uncontested facts that LBC has utility and some buyers acquired it for consumptive use to the conclusion that LBC is not a security. That's kind of, isn't that ironic? Claims that Library is engaging in the same behavior that the judge is actually engaging in. Yeah, it's not lost on me. Anyway, Attorney Bill continues. The judge does not give much weight to the evidence of consumptive use, which in fact was the only evidence of what actual LBC holders did or believed in the case. Yeah. So not only that, think about that. The evidence is to the contrary of the conclusion the judge came to. Like, what do you do with this? This is real life, folks. Attorney Bill continues. His reasoning on page 18 seems to be because the law allows him to find that some consumptive use does not mean there is no investment contract, and the consequences were it otherwise. He finds the evidence of what actual LBC users did of limited relevance. That's a quote. In contrast to his conclusions about what hypothetical investors would have objectively expected from knowledge, assuming they had it, of Library's thinly evidenced representations and business model. 18 months of litigation and millions of dollars in legal fees for a 21-page judgment like this. It is basically fact-specific based on evidence of specific and not many Library representations and about one part of the Howey test. This decision will not make Ripple shake in its boots. Exactly. Excellent thread and analysis. And probably tomorrow I'll put out a video because I do want to talk more about what happened in the Library case, while tragic and awful, and admittedly it would be like a death blow to crypto if it were the law of the land. It's not the law of the land. And not only that, this isn't going to impact the Ripple case negatively in all likelihood. So I'll be talking about that tomorrow. But I'll wrap up here. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Lambo.